Lots of changes, and change could be one of our big themes here today. And one of them is what is going to happen, some changes, proposed changes to the trial system. Often the legal system and lawyers are weighing in on things that they think are going to have massive changes to justice. And it really is incredible how often justice has come up this year, whether it is in Canada or the rule of law or whether it is in the United States of America. But there is a lot of focus on this. Lawyers in Canada, some lawyers are worried about these proposed changes to the trial system, and this has come after a very, very high profile trial, and the focus was on the Gerald Stanley trial, and we remember that there was a recommendation that visibly Indigenous potential juries be allowed to be on that jury to make sure it happened. And one of the criticisms was that these potential jurors were released and were not part of it. So it caused a big conversation about the makeup of a jury. How important is it? And for some lawyers, some of the changes that are being proposed are knee-jerk and unnecessary. Joining us is Joseph Neuberger, who is a Global News Radio legal expert and lawyer with Neuberger and Partners. Welcome, Joseph. Nice to talk to you again.
Nice to talk to you, too.
How are you viewing this? There's a whoa. I think we have lost Joseph. I understand the crackle after a while. While we get him back on, we are, of course, talking about a story, the Gerald Stanley trial. And that was after the death of Colton Boushey on a back road. And remember how often that was in the headlines. It was enormous. The trial itself and this kind of stand your ground theme of the trial, and then the criticisms after on what went wrong in that trial. And the recommendation was that juries should have visible minorities on there if that is what pertains to the legal topic. And in this case, it was visibly Indigenous potential jurors, and this may go through. Joe, welcome. Thank you for being here.
Sorry about that. I'm back.
All right. Glad to have you back. How do you feel about this? I mean, this was such a high-profile trial, and when things are high-profile, there's always a knee-jerk reaction that we have to do something. Is this the correct thing to do?
No. In fact, this is quite the wrong thing to do. And what's really astonishing for 2018 is how much knee-jerk reaction legislation has come out from the Liberals. So this is but one. There's Bill C-51, which just got royal assent because of the Gomeshi case, and it's changed sort of the landscape of how you have to litigate those cases. And that's because the government didn't like the verdict and because there was some special interest groups speaking out. This unfortunate shooting out west was a verdict that people didn't like, but because there was no Indigenous member on the panel array that was accepted, therefore we have to get rid of a number of things, including to get rid of these challenges so that it will be allegedly more diverse. The difficulty is this type of peremptory challenge came into place originally to protect minorities. So the idea was that lawyers who represent their clients and those who represent the Crown each have 12, and they have a better understanding of what may be in the best interests of their client and be able to give them a fair trial. Eliminating this now leaves it to a challenge for cause, and who knows how that's going to work out now. But what I see is constitutional challenges by lawyers to just create greater latitude for these challenges now.
And let's do a little bit of a deep dive in how this could affect the jury, because that was the recommendation here. What will these changes do to the makeup of a jury?
I really don't know. It's random. People are randomly selected. So you get, let's say, for example, on a trial that's going to go a week or so, you may get 200 people in a panel, and then of that, names get randomly selected. And they stand up, and there's this archaic way of doing it where the potential juror looks at the client and the client looks at them, and then a lawyer could decide challenge, and it's without having anybody else overrule us. Now, neither the Crown nor the defense will have that. It may be that the first people who are randomly selected could be all white, could be all of different color or different, like there's just nothing there to try and create the diversity that we want, and will force lawyers practically to make applications to the court to widen up our ability to challenge potential jurors so that we can have an inclusive and fair trial.
Now, wouldn't it be possible that the challenge to the jury would benefit some minority people who are charged with things like Indigenous clients? Because as you say, if randomness got all white people on the jury, so do you have any idea what the thinking is about this, or is this just about doing something because of the public outrage?
This is just doing something without proper thought. I mean, the reality is, I've had many cases where members of your own community are probably the worst ones to judge you sometimes. And so, I think when I was reading the article, a professor in Calgary who I happen to know well, Lisa Silver, had said, many lawyers who have had Indigenous clients may want to exclude Indigenous panel members so that they have a fair trial. Doesn't mean that not all individuals who come before would be able to do a fair trial, but you don't know. This does absolutely nothing to promote diversity on a jury panel, and it certainly takes away from the fairness of a trial for people who are accused of offenses.
All right, let me ask you, is this a trend? You brought up the Ghomeshi trial, saying that, and you used the word that this is a push from the liberals to do this. Is this political?
I see it as totally political. I see this as meeting the agenda of this particular government, which has promoted Indigenous rights, and that's fine. But they've also taken certain positions with respect to how the criminal justice system deals with certain type of offenses, and this is part of their mandate. It's a way to garner public, sentiment and to play on the interest groups who had voiced their concerns about these verdicts. I don't see this as advancing the system of justice. I think it's going to make it more complex now, and it's going to have quite a bit of harm.
What about the Ghomeshi aftermath? I mean, after Ghomeshi, of course, we had Me Too, and there was a focus on maybe how we deal with stuff. Sometimes we can do better. Was there any movement forward, or you think it's the same kind of a knee-jerk reaction here?
It's, again, poorly thought out. So what happened was one of the major changes is now, because in the Ghomeshi case, like many cases I defend, there are communications between the complainant and the individual accused that are about the actual subject matter of the charge. And it can be those messages where it's like 2 days later, I love you, this was fantastic, I had a great time, and not a hint at all about what's being complained of. And so in cases I have, sometimes we have hundreds of messages. And you were never forced to disclose those messages prior to trial. A lot of the time we would, but we certainly did not have to seek any type of permission from a judge on a motion. They have now created a system where there has to be a motion for any type of communication, picture, whatever, even if it's regarding the actual offense itself. And that now creates a whole other layer and an issue of access to justice. And I think it's a knee-jerk reaction which will not provide any sort of meaningful benefit to the justice system at all. It's up to judges and it's up to juries to decide guilt or innocence. It's not up to the government to do that and try and tip the balance in favor of one party versus the other. That's actually wrong. We shouldn't have governments do that.
Joseph, look at how often the focus really in Canada and in the United States as we look on the rule of law. Is the rule of law under political small a attack this year?
That's an excellent way of putting it. I think you're right. I think you're absolutely right. We are seeing politics overtake fairness and justice principles that's been in place for years upon years for good reason. You're right. That's an excellent way of putting it.
And it's kind of dangerous, isn't it? Because, and we're looking at it now as we talk in a nonpartisan. You're looking at what the liberals have done here, and we're watching a president in the United States fight things off. But over and over again, and I got to be honest with you, I've laid awake at night worrying about this a little bit. We took it all for granted, didn't we?
Yeah. We did, and now we're seeing unprecedented changes, in my opinion. The law has to advance to understand, how society is. That being said, we're taking steps backward, and what we're going to do now is put tremendous pressure on the justice system because lawyers are going to challenge. I'm going to challenge Bill C-51 the first chance I get. We're going to see challenges to the new impaired driving legislation, where there's these mandatory roadside testing, which again doesn't advance anything. We are going to, and that's because the marijuana laws were so improperly conceived. So this is a political small a attack on it. We're going to see a lot of ramifications from this that's not good for the justice system. It's not good for the community, and it's going to create expense, time, and delay in the courts.
This is an election year, and as you talk about it so often, let's face it, we're going to hear about this from the Liberals on the campaign trail. We did this, we did that, and when it comes to drinking and driving, let's face it, it takes a little bit of courage to push back on this. But again, it is about tipping the balance of the rule of law and people's rights.
Yeah, absolutely. And so, reasoned individuals who are well informed about this can have important discourse at the political level, but we're not having that right now. And I'm concerned because I don't hear much coming from any other sides to try and deal with it, because from a political perspective, you don't want to be on the side of an accused individual. That's just politics. And that's wrong, because we have to protect individual rights. It's a democratic principle for us that we have fair trials and we have rules of evidence, and that's for all our protections, including you and me. And you'd be surprised when people come to my office and it's a family member who's charged. They're like, how can this happen? And I'll tell you why, but pay attention to who you elect.
Pay attention. What about the justice system? What about lawyers? Should they have been more involved in this?
Well, there was some standing committees. I'm not sure how they chose who to speak to, and I just don't think nothing went through with any amendments. They didn't listen. They don't care. They're not paying attention to the stakeholders. There are many Crown attorneys who will say the exact same thing as defense lawyers, we should not get rid of these peremptory challenges. Preliminary hearings are important hearings. They need to be managed properly, but they should not be eliminated. Mandatory testing is not a great idea. There's nothing wrong with having some evidentiary foundation. You'll hear this from Crown attorneys, not just defense lawyers. So no, I don't think the consultation process was anywhere, sufficient. But more importantly, I think it's just individuals who just want to appease particular groups for political reasons, and that's what you're suggesting, and I'm agreeing with it, and I'm wholeheartedly endorsing it.
All right, finally, a final question. How much does public sentiment affect the rule of law? This is something else we saw. We saw it with Ghomeshi. We've seen it with the knees together, Judge. We've seen it. You're talking about precedent and making sure that justice and the balance and the scales are equal. But public news and sentiment and passion affects decisions.
Well, we are very lucky in Canada to have non-elected judges. I know many who are judges, and they want to get it right, and they want to be fair to everybody. So if the public is somehow concerned that our judicial system isn't working well, that's not true. It's an excellent system. It's a beacon in this world. Second, the difficulty is it's 2 cases or 3 cases we can point to in a year. There's thousands of cases every month litigated across this country. There are thousands of resolutions. Nobody hears anything about that. Nobody complains. It's only about 3 high-profile cases where they didn't like the verdict. Too bad. That's a justice system. And you can't tip it in favor because the politics is bad or the public sentiment about it. We cannot, run trials based on public sentiment. That will become very dangerous for our society.
Joseph, thank you for joining us. Happy New Year's to you. Thank you for being here.
Happy New Year. All the best.
All right. Cheers. Joseph Neuberger, Global News Radio legal expert and lawyer with Neuberger and Partners. We're going to take a break when we return, and it's our time to talk about stuff that's going to happen and stuff that has happened, as we just talked about the rule of law. And I worry about that. I've had a few nights where all of a sudden I thought, I took that all for granted.